Yeah, it's gonna be one of them long videos. So if you're chilling, you're chilling. If you're not, you're not. But let's get into it from the U-Haul box, according to Woody. Let's do it.
This, this right here, this is going to be good. I already know how petty Steele writes, so let's do it. Just to start it off, motion for a fair trial as well as motion for a list of dates/persons who participated in any ex parte communications with the court and the topic of same motion for mistrial based upon judicial and prosecutorial misconduct, and thus bar retrial. Comes now. Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion for a fair trial, as well as a motion for a list of dates/persons who participated in any ex parte communications with the court and the topic of same. Motion for mistrial based upon judicial and prosecutorial misconduct and thus bar retrial in the above referenced case. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all crimes in the above referenced indictment. From the inception, this trial has been constitutionally unfair as this court has failed to be impartial to Mr. Williams and or his counsel and has been objectively biased in favor of the prosecution. Some examples of this include, but not limited to, the below. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27, 2023, so that objections could be made prior to presentation of the opening statement. On Friday, November 24, 2023, at 4:58 p.m., Lawyer Love shared her purported demonstrative aid via email. During opening statements, however, Love showed a completely different, never-before-seen demonstrative aid, which was in clear violation of the court's order. The court denied Mr. Williams' timely motion for mistrial, and there were no consequences meted out by the court for Lawyer Love's intentional misconduct. Now, if y'all don't remember, basically, she burden shifted. She literally said, which they should have had a mistrial right there. Brian Steele is 100% right on that. They should have had a mistrial right there. She said that, let me click in my memory real quick. She said that the defense would show no proof of them being innocent. That's burden shifted. The burden is on you to prove their guilt beyond reasonable doubt. And that's literally what she didn't say. She said, they ain't gonna show you nothing to show that they're innocent. Wrong, they ain't gotta do that. During the same opening statement, Lawyer Love defied another court order, by introducing to the jury that undersigned counsel had represented other charges in this case. Granted, Mr. Williams' motion in limine number 23 attached here too, specifically during her PowerPoint presentation, Lawyer Love highlighted to the jury that undersigned counsel represented co-indictee Blaylock. Again, there were no consequences meted out by the court. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury witness Mr. Bean was taken to Grady Hospital by police directly from the scene of his arrest September 11, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence, as Mr. Bean never went to Grady Hospital on September 11, 2023. Lawyer Love allegations against undersigned counsel were proven beyond any doubt to be totally knowingly false, yet the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. I don't want to read all these stupid links. So, over Mr. Williams' objection when the state was attempting to introduce the January 2026, 2015 social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the court that only Mr. Williams' voice could be heard on this video, except for one other voice saying words like "yeah" in the background. Undersigned counsel told the court that Lawyer Love was incorrect and that several persons' voices were audible on the social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting facts to the court. Of course, Lawyer Love was proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. Although it was objectively proven that Lawyer Love falsely accused another member of the bar of misconduct, lying to the court did nothing to admonish Lawyer Love. This pattern of permitting prosecutorial misconduct illustrates that the court wrongly favors Love and the state of Georgia in this case. On Thursday, June 6, 2024, as well as Friday, June 7, 2024, Lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Mr. Copeland. This was another knowing malicious false allegation by Lawyer Love. The court remained mute and failed to admonish Lawyer Love. On Friday, June 7, 2024, Lawyer Love falsely accused counsel for Mr. Copeland of violating his ethical duty to his client. The court remained silent while Lawyer Love heard more false allegations. In the jury's presence on separate occasions, the court wrongly accused undersigned counsel of being unprofessional as well as unprepared. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, and undersigned counsel was neither unprofessional nor unprepared. The court's overly prejudicial and improper conduct towards Mr. Williams and or his counsel in its refusal to instruct the jury to disregard those impermissible and false allegations, as well as the court's failure to apologize for these baseless claims, proves bias for the state and prejudice against Mr. Williams and or his counsel. The above few examples raise reasonable questions concerning the court's partially and bias against Mr. Williams and his counsel's efforts to obtain a fair trial and a fair tribunal without prosecutorial misconduct. The court's impartiality is objectively questioned, and the court must be recused. This court has falsely and wrongly accused undersigned counsel for being unprofessional and unprepared in front of the jury. Neither claim has any modicum of truth. The prosecutor sat silent as the court wrongly and falsely accused undersigned counsel of improper conduct in front of the jury, all prejudicing Mr. Williams. The court has violated its duty of neutrality and impartiality that is sworn to undertake. Even knowing that the court has falsely accused undersigned counsel of being professional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper, highly prejudicial comments. This conduct shows that this court is biased against Mr. Williams and or his counsel and favors the state, as no unbiased judge would not correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven. To date, the court has done absolutely nothing to stop Lawyer Love from continuing misrepresentations, abuse of others, and false allegations. Instead, on occasion, the court speaks in generalities to remind both sides to be professional. This is not a both sides issue. This is a one-sided issue resulting in prejudice to Mr. Williams and a violation of his constitutional right to a fair trial. Mr. Williams languishes in jail without bond since his arrest on May 9, 2022. Mr. Williams has been and is being denied his constitutional right to due process, a fair tribunal, and a fair trial based upon prosecutorial misconduct and judicial misconduct. The court has exhibited a pattern of biased behavior of the state and against Mr. Williams and or his counsel, and the court has failed to admonish Lawyer Love to prevent her past and continuous misconduct. The failure to act by the court has emboldened Lawyer Love to persist in engaging in misconduct. The court has effectively joined the prosecution. The court has effectively joined the prosecution team by permitting Lawyer Love to defy court orders without consequence. The court has imposed absolutely no sanctions to stop or deter this prosecutorial misconduct. As a result, Mr. Williams has not received a constitutionality-mandated fair trial, does not have a fair tribunal, and his due process rights have been repeatedly violated because of the professional and judicial misconduct, because the state has blatantly violated Mr. Williams' rights. They have goaded Mr. Williams into making motions for mistrial, all of which have been denied. The above few examples are egregious and cast a dark, ugly stain on the Georgia's judicial system. The below further captures the violation of laws that lawyers Love and Hilton in the court display herein. On Monday, June 10, 2024, the court, along with lawyers Love and Hilton, engaged. Man, we're not doing this crap. Yeah. Because it ain't doing nothing but talking about basically the freaking ex parte meeting. And furthermore, Mr. Williams requests a list of persons involved, the topic of the same, and transcript of ex parte meetings, if any, conducted by the court involving anything to do with this case/trial. Additionally, Mr. Williams also moves that any document that is filed under seal be reviewed by a neutral judicial officer to determine whether same needs to be unsealed and shared with Mr. Williams under statute and/or constitutional provision. Wherefore, undersigned counsel respectfully request that Lawyer Love be barred from uttering false allegations or displaying words towards another. Lawyer Love conduct herself with professionalism and in full compliance with the Georgia rules of professional responsibility, which given the court of lawyers in the state of Georgia, if able, and a mistrial declared based upon Lawyer Love, Lawyer Hilton, and the court's failure to protect the above stated constitutional rights, as well as Mr. Williams' right to be present under Article 1, Section 1, Paragraph 7 of the Georgia, that'd be Paragraph 12, of the Georgia Constitution. Its federal counterpart, the right to confront witnesses, the right to a fair tribunal, the right to a fair trial, right to due process, right to present a defense, and to call witnesses the 10th day of July, respectfully submitted Brian Steele and Keith Adams. Now, this is talking about essentially ordering granted defendant Williams motion in limine number 23 filed on July 27, 2023 after hearing from parties on August 31st, 2023. Specifically, Brian Steele, on behalf of Mr. Williams, represents the Fulton County District Attorney's Office on behalf of the state of Georgia. Honorable Court grants Mr. Williams motion in limine 23 concerning the fact that other indicted persons in the case sought or actually retained Attorney Brian Steele. This honorable court already held in conflict hearing and denied state's efforts to remove Attorney Steele. Yeah, they did do that. So he's talking about when they try to get rid of Steele, and basically, it's not the same move that Steele did, but basically, before the trial started, there was Miss Love trying to get rid of Brian Steele, and basically the judge denied it, but it was a thing for a good, I'd say, week, because the judge even said to Brian Steele, you put yourself in this position, when it's like, bruh, this is his job. He's a lawyer. He can represent whoever the hell he wants to. And then they basically had said to the effect of, oh, he can't do that because he's not going to be impartial towards his clients if a deal comes up. And Brian Steele's like, listen, if a deal comes up, I will present it fully to my clients on the motions for whatever. Like, try to basically sign a plea agreement. That's what it was. So that's what they were trying to do. Ultimately, y'all seen how that worked out. State's response to defendant's motion to recuse Chief Judge Earl Glanville in the trial of the above style case. Introduction. Midway through this now months-long trial, defendant Jeffrey Williams and defendant DeMonte Kendrick have filed a motion to recuse Chief Judge Earl Glanville hereinafter motions, and defendant has filed a supplement to the motions hereinafter supplement. The state recognizes that Chief Judge Glanville has reassigned a motion and that it has been properly reassigned to this honorable court. But the state respectfully submits that at the time of reassignment, Chief Judge Glanville did not make the three requisite determinations: whether the motion was timely filed, whether the affidavit made in support of the motion is legally sufficient, and 3, whether if some or all of the facts set forth in the affidavit are true, recusal is authorized. Accordingly, it falls to this honorable court to make those determinations. As set forth below through defendant's motion and supplement are in part timely, the affidavits in support of defendant's motion and supplement are in part legally sufficient. None of the facts set forth in defendant's affidavits, even if assumed to be true, would authorize recusal. Defendant's motion and supplement should therefore both be denied. All right, so where's your case law, though? Where's your case law? Whatever. This is, bruh, this is about to piss me off, man. Factual background. A, the calling of state's witness Kenneth Copeland on June 7. On June 6, 2024, in response to an inquiry from counsel for the defendants in this case, the state announced that Kenneth Copeland would be the state's next witness and will be called to testify on June 7, 2024. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communications with Mr. Copeland and that Mr. Copeland will be asserting his Fifth Amendment privilege. If called to testify on June 7th, perplexingly, given that Mr. Copeland was being called to testify against Williams and Shannon Stillwell, who are represented respectfully by Brian Steele and Max Sharp. Melnick copied Brian Steele and Max Sharp on his communications with the state regarding Mr. Copeland's intention not to testify. But that's not illegal. All right. In preparation for trial, Deputy District Attorney Deputy Hilton, along with her investigator, had met with Mr. Copeland on multiple occasions, and at no time did Mr. Copeland state an intention to plead the Fifth or say he was represented by Mr. Melnick. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Copeland until June 7, 2024. Miss Hilton, that don't even matter. In that 3.5-hour interrogation video, the damn investigator knew that Melnick was his lawyer and Steele held the guy. Man, this is, boy. Pursuant to OCGA 24-5-507, after receiving Mr. Melnick's email, the state presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland, extending immunity to Mr. Copeland for his testimony, and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court. After being granted immunity, the court issued an order granting the state's motion on June 7, 2024, after the court was called to order Mr. Melnick appear before the court and inform the court that Kenneth Copeland will be asserting a Fifth Amendment privilege against self-incrimination and the presence of each defendant currently on trial and each of their respective attorneys. Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state had sought and been granted an order to the court pursuant to OCGA 24-5-507, directing Mr. Copeland to testify and extending immunity for Mr. Copeland's compelled testimony. Chief Judge Glanville further explained to Mr. Copeland, in the presence of every defendant currently on trial and each to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. Mr. Copeland thereafter stated his intention to testify. Wow. Yo, she tripping. You left out a whole lot there. Mr. Copeland thereafter stated his intention to testify. Mr. Melnick looked toward Mr. Steele and Mr. Sharp and shrugged his shoulders. After motions hearing, the court recessed for lunch. During the lunch, Mr. Melnick spoke with counsel for his defendants, but at no time attempted to communicate with the state, which he doesn't have to. After lunch, the jury was called in, and Mr. Copeland took the stand. Mr. Copeland cheekily answered a few questions, and when asked his age and years, Mr. Copeland responded, "I plead the fifth." The court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt, and ordered Mr. Copeland in custody in open court in the presence of all the defendants currently on trial and in the presence of each defendant's respective attorneys. Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back into court Monday on June 10th to allow Mr. Copeland to purge himself of his contempt by testifying. Mr. Melnick announced that he was going on vacation, would in no way be present on Monday, and would appoint stand-in counsel Caleb Bumpus to represent Mr. Copeland. On June 10, 2024, meeting regarding contempt proceedings initiated against Mr. Copeland upon motion of the state, attended by counsel for Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Chief Judge Glanville. There were more people at that meeting, but all right. On Monday morning prior to the start of court, the state requested from the court an in-chamber meeting with counsel for Kenneth Copeland, the court, and an attorney for the state to discuss the contempt proceedings initiated against Mr. Copeland. Upon the state's motion, the court granted the state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. Present during the meeting were CDDA Love, attorney Caleb Bumpus, investigator for the state and Honorable Chief Judge Glanville, and later Kenneth Copeland and DDA Hilton. Matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed included Mr. Copeland's rights and representation as it relates to the proceedings, Mr. Copeland obligations under OCGA 24-5-507, and answers to questions posed by Mr. Copeland regarding matters related to OCGA 24-5-507, such as the distinction between purging oneself of contempt as addressed by, we ain't finna even do all that. Let's just skip down, bro. Because she's basically, she summarized it so succinct that it's funny. Because she's missing a whole bunch. To warrant disqualification of a trial judge, the affidavit supported the recusal motion must give fair support to the charge of a bent mind that may prevent or impede impartiality of judgment. To be disqualified, the alleged bias must stem from an extrajudicial source and result in an option on the merits on some basis other than what the judge learned from his participation in the case. Emphasis added. There is a presumption that a trial judge acting as a public official faithfully and lawfully performs the duties developing upon him, determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. Here, with the exception of the defendant, Mr. Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the court for being prepared, defendant's motion and the supplement are based entirely on the defendant's assertions regarding that the June 10th, 2024 meeting regarding the contempt proceedings against Mr. Copeland and actions taken by Chief Judge Glanville after Mr. Steele defiantly refused to comply with the court's repeated requests to provide the court with information. I wish she would have got more petty than that, but whatever. GA Code of Judicial Conduct 2.9 regarding ex parte communications provides that judges shall accord to every person who has a legal interest in proceeding or that person's lawyer the right to be heard according to law. Emphasis added. However, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated or motion by the state involving Kenneth Copeland's refusal to testify, since no defendant in this case had a right to be present at the June 10, 2024 in-chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceedings against Kenneth Copeland. The fact of the meeting provides no grounds for recusal of Chief Judge Glanville. Respectfully submitted this 10th day of July, 2024. Adrian Love. Now, what I will say is, Miss Love didn't have to address the quote-unquote recordings and stuff like that because she ain't got to. That's up to a judge. So I disagree with everybody saying she had to address this and had to address that. Hell nah. For what? You don't talk about that at all. You leave that for the judge. She basically said wasn't nothing wrong with what we did. So for her to go through and then basically say this thing is wrong, this thing is wrong, and I know y'all gonna be like, oh, you're being biased. All right, whatever, cool. Y'all just gonna say whatever y'all want to say. At this point in time, nah, I'm gonna be fair. Like, she shouldn't have. But what I would like to do is go over Conduct 2.9. So I'm going to screenshot this right here. And we're going to see if she did something that I don't like. But look at the footnotes right here. Citing King versus State, 273 Georgia, and holding that an appellant had no standing to contest the grant to use immunity of a witness, King versus State. So outside of presence concerning the state's request for an order compelling the witness to testify at trial, confirming the use. Yeah, ain't nobody tripping off you using the immunity. They just said it was a dirty tactic. Just because you do something that they deem dirty doesn't mean it's illegal. It's like playing basketball and somebody is about to dunk on you and you take a charge. Like, technically, yeah, it ain't illegal, but it's dirty as hell. This trash as hell. All right, 2.9. This is what y'all come to right here. This is why y'all come to the channel, because I used to do this, so my apologies to everybody that I stopped doing this. But yeah, I used to do this all the time. We would go through the freaking what's the names, and this is where the term hood lawyer came from the visionaries. And let me say this too, because I'm about to piss in some people's goddamn Cheerios. Just because you've been to court, like as a felon or anything like that, just because you cats done been to court, you're not a lawyer. Bro, I've been to court as a juvenile and helped defend myself. So when y'all talking, that's like somebody said, oh, I've been shot, so that make me a gun expert. No, the hell it don't. So I see some of you losers in the comments, bro, you never even did this, never even did that. The same way you niggas to sit on the couch and play Monday morning quarterback. The same way y'all put on jerseys of people and act like you actually in the game, yelling at TV screens and stuff like that for any freaking sport. Shut the hell up. I can tell you a whole entire thing. Matter of fact, I've cited case law. Hybel versus Texas for when you morons get pulled over in a damn car. And I tell you guys, hey, make sure you ask the cop, is this a Terry stop? Because if it's something as a simple traffic infraction, they have no right to ask everybody's identification in that car because it's a traffic infraction. Now, if y'all all are being accused of a crime, then, hey, you know what? Then they have a right. Yeah, I just gave y'all some game. But anyways, let's go. Rule 2.9, ensuring fair hearings and averting ex parte communications. Judges shall accord to every person who has legal interest in a proceeding or a person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matters subject to the following exceptions. See, and that was one of the things that people just kept on doing, and they literally did not put the last part. Subject to the following exceptions where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. Y'all seen this before from me, right? I'm the only person on YouTube that was putting that up. The only person. The judge makes provision promptly to notify all other parties of the substance of the ex parte communications and gives the parties an opportunity to respond. Now, the word promptly is the one that is debated amongst everybody because we had to look up what promptly really means. Judges may obtain the advice of a disinterested expert on the law applicable to the proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice and afford the parties reasonable opportunity to respond. Judges may consult with court staff and court officials whose functions are to aid in carrying out adjudicative responsibilities, or with other judges, provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. Judges may, with the consent of the parties, confer separately with the parties of their lawyers in an effort to mediate or settle pending proceedings. Now, if she were to point this one out, that would get a little tricky because Melnick basically wanted out because he knew Woody was going to lie. Now, that's the part right there where I kind of sit back and I go, that's going to be on the judge. Because essentially what you're saying is that we can hold these ex parte meetings without the other side if we choose to do so. But like I said, they still had to let the freaking the other side know eventually. Judges may initiate, permit, or consider ex parte communication when authorized by law to do so, such when issuing temporary protective orders, arrest warrants, or search warrants, or when serving on therapeutic problem solving or accountability courts, including drug courts, mental health courts, and veterans courts. If a judge inadvertently receives an unauthorized ex parte communication bearing upon the substance of a matter, the judge shall make provision promptly to notify all parties of the substance of the communication and provide the parties with a reasonable opportunity to respond. So that's what a lot of people are pointing to. But what I would tell y'all is that ain't really this, in my opinion. In my opinion. Because every lawyer is opinion based, because I start telling y'all, start to cite me court law, and none of y'all could do that. So judges shall not investigate facts in a pending proceeding or in pending matter independently, and in making adjudicative decisions shall consider only the evidence presented and any facts that may properly be judicially noted. The facts a judge shall not investigate include those derived from personal observations or media, including permitted publications, computer retrievable electronic data or internet or social network communications. A judge shall make reasonable efforts, including providing appropriate supervision to ensure that this rule is not violated by the court staff, court officials, and others subject to the judge's direction and control. Commentary: judges shall immediately stop any attempted improper ex parte communication. Rule 2.9b does not excuse a judge from his ethical requirement. 2. The right to be heard is an essential component to a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. See Rules 2.7 to 2.9 addressing limits on the scope of evidence that may be legitimately considered by the court. In recent years, jurisdictions in Georgia have created what are often called therapeutic problem solving or accountability courts, including drug courts, mental health courts. That ain't got nothing to do with this crap. So basically, judges may consult with other judges on pending proceedings and pending matters. Basically, I'm not seeing nothing. Like I said, I'm not seeing anything. But let's get into it.
Now, like I said, I don't think Love should have addressed a bunch of what Brian Steele said. Some of y'all gonna disagree, and here we come with you being biased. All right, cool. I don't think you addressed none of that. In the Alec Baldwin trial, right? The guy basically was saying, we're not going to dispute how she, that she died and, the bullet went through her lung and severed her spine and went out her spine and then lodged in this guy's shoulder. We're not going to dispute any of that. And there were certain things about how Donovan Thomas perished that the defense didn't dispute. There's certain things you can't get married to, or you're going to literally say, this is true. So some of y'all disagree with it, cool. But whatever. I wish Love would have put more case law into it to help out. You filed it 45 minutes after the deadline, which it should be rejected, but it's more than likely not. And if it's not rejected, that goes more into the court being biased. So Love, you get an F. You get a big ass F. You get an F- with a big freaking yellow sign because you pissed all over this. You had one job. You have underlings. Now, what I know from how you act with Hilton, you micromanage a lot. So I think she had to go through and read all this crap and everything. I was like, this ain't right, take this out. This ain't right, take this out. There is something to be said to be succinct, which means use less words, because your boy Brian Steele is very verbose, meaning very wordy. But what he does is he tries to strike a nerve, and I think he did that. Now, I ain't gonna hold you. Brian Steele should have put, this is my opinion, I know people are finna get pissed off. Brian Steele should have basically said, get her ass off of there. Even if we proceed, Love gotta go. That's what Steele should have did. Steele should have pushed for Love basically to get kicked off as well. Like, if y'all don't want to do this, or do this, or do this. Basically saying, let's get a mistrial. All right, if we don't get a mistrial, tell the judge, hey, stop doing that, bro. We doing right over here. And then he basically like, y'all need to talk to Love. What you should have said before y'all need to talk to Love is, you guys need to kick off ADA Love, because essentially she is tainting the jury, she is tainting the prosecution team, she is tainting the whole entire judicial system and the proceedings of this court. I would have been like, holy hell, god damn, you basically saying you a dirty mother sucker, you mother sucker. But he didn't do that. Now, what I will say is, once again, even if the judge isn't booted off, Steele and them won. Because what they're doing to the judge is saying, hey man, you're behaving wrongly. And we have it in our powers to just go ahead and stop this court and tire out the jurors and do all of this stuff. And next thing you know, it's going to get ugly. Because I think part of the strategy too is, a lot of y'all don't know this, but a lot of cats, with the exception of Funk, have not been getting in trouble. And those freaking, what's it called? Those deals that they have, well, in December of this year, they're set to expire. Which means, bruh, if I'm on probation, I can leave. And it wouldn't surprise me if the slats, the slimes, anybody like that, got the hell out of Georgia as soon as probation ended and moved out of Georgia, and they can't find them to testify. Now, some of y'all gonna say, damn, Nash, why would they do that? Well, let's think about it. All it is about trying to make sure that YSL is painted as an entire criminal organization, because being a gang isn't illegal. But if you don't have people's testimony, because you have a right to have what crime you're being accused of by somebody else be examined in the court of law. But if we can't examine it, you can't bring it up. And that right there will deliver a blow so bad that it would look damn near genius on behalf of the YSL lawyers, which I don't know if they're doing. I have no way of knowing that. But yeah, December, yeah, it's going to be time. And since it's going to be time, it's going to get interesting. But I will say this, the need for the speedy trial and all this crap, bruh, beautifully orchestrated. Because I ain't going to hold you, the DA's office is pretty goddamn pathetic right now. But share to keep your people aware, subscribe to my best, stay notified. I'll catch you on the next one.